Hcmc stock news update. We all know by now that Philip Morris has now lodged its response in opposition to the motion for leave to amend. So in this video, anytime we mention complaints, we are referring to the initial complaint filed last year, and then the amended complaint is the one that was filed on the 6th of August this year. So, and there are two parties named in this, especially at least one party we are going to discuss this. It is Dr. Hcmc. So let's have a look and see him here. So he is the director of product research at Philip Morris. So let's move on to this. This is the introduction, and straight away they went out and clearly asserted that Philip Morris and Philip Morris SA, that is the one probably in Switzerland, and Philip Morris USA Inc., their device, the IQS, is indisputably a heat not born product that is engineered so no combustion can occur, as set forth in the FDA documentation. Plaintiff Hcmc introduced in its lawsuit that Philip Morris demonstrated the absence of combustion to the FDA before the FDA had authorized the defendants to sell the IQS in the United States. So, they are now, as you can evidently see, they are relying on the fact that complaint was dismissed. This is what they are trying to get at. That is that it was dismissed on the weight of the FDA documentation that IQS does not combust. They assert that Hcmc seeks to contradict the plain meaning of the term combustion from the meaning that binds Hcmc in the prosecution history of the asserted patent. So we will see what that prosecuted history of the asserted patent. So this is the prosecution from the patent office. So we're going to discuss that as the video progresses, and also when we are looking at the declaration of Dr. Hcmc, we will see that prosecution history. Okay, so in page 6, which is just the next one here. In page 6, they asserted that Hcmc's proposed amended complaint changes nothing. Okay, that is it stated here. In the proposed amendment complaint lodged on August 6, 2021, motion for leave to amend, Hcmc tries to redefine combustion in contradiction to its undisputed pleadings of record, including the asserted patent and the FDA document it relied on in Exhibit J in its complaint. So Hcmc cannot state a plausible claim of infringement by redefining the term combustion at odds with its patent's intrinsic record and extrinsic evidence attached to the complaints. So and then in page 7, there's no discussion whatsoever in the 170 patent about different types of combustion. This is what Philip Morris is alleging, or what temperatures may be required for an exothermic reaction, much less a statement in the patent that defines combustion in the way Hcmc now proposes. So this is where we meet the factual and procedural background. Here indeed the patent does mention combustion and combustible materials and all that stuff, just mentions things that will, ultimately result in combustion. So Philip Morris is now saying that it does not discuss whatsoever in the 170 patent about different types of combustion, So what we clearly see is that Philip Morris is trying to assert that Hcmc did not define combustion elaborately or verbally as it has done in the proposed amended complaint. Even though we can see that the definition of the proposed amended complaint gives more flesh to what is stated or covered by the 170 patent. So, and then we can move on to page 9. We can see here that here we see the HCMC's complaint alleged combustion. Okay, so here they indicated that on February 12th, 2021, they wrote to HCMC to assert that their infringement allegations were baseless because, first of all, the FDA approved IQS does not combust as required by every single claim of the asserted patent. So we are going to come back to all of these FDA approvals and other stuff. So if HCMC alleged that combustion in the form described in the 170 patent was not necessary, then the asserted patent was invalid because the lack of combustion was the sole distinguishing feature that HCMC told the patent office justified issuance of the patent. So it is clear here that combustion is indeed a burning issue, and we know that for sure. We know that combustion is the burning issue. So we're now asking, why would Philip Morris assert that the IQS is a heat not burn product, yet it is trying to fend off any allegations of the IQS combusting at the same time, and also trying to assert that the HCMC patent is invalid, that it was granted a patent based on the grounds that it does not combust. Why is Philip Morris now doing this? You understand? You understand that the question marks, and I'm asking here, why are they doing this? So we'll just move on straight on to page 24. Here they indicate that firstly, because HCMC attached exhibit J and other FDA documents to its complaint, HCMC cannot challenge the authenticity of those FDA documents, because in those documents it was stated that the IQS does not combust. Okay, so I mean, it's trying to say that HCMC cannot. I mean, even though yes, we have seen that we have seen that the case was thrown out. So again, they are relying on what the precedent, what has happened. The case was dismissed initially because the FDA document stated that the IQS does not combust. So secondly, the FDA documents are central to HCMC's claim. Even HCMC's amended complaint still relies on PMSA's interaction with the FDA. Okay, so we move on to the next table here. Here we can see that they have this question here. This table, amongst other things that was asked here, was said test accused IQS device. FDA answer is yes, and Dr. Dybel answer is no, but that's not as relevant as this one. Low levels of carbon monoxide, nitrogen oxide gases indicates combustion, a question. FDA answers no, and Dr. Dybel answers yes. So remember, Dr. Dybel is the expert that provided the declaration in HCMC's amended complaint. Okay, so Dr. Dybel is saying yes, combustion does occur in the IQS, but Philip Morris is relying strictly on what the FDA has stated. No shaking, no equivocation. We're not giving up that ground. That's what they are trying to assert. Okay, so we'll just move on to the declaration of Dr. Segemida. So he has a PhD from Swiss Federal Institution of Technology. He got it in 1996. The PhD is in polymerization, kinetics, and engineering. So I think it seems the other experts, Dr. Dybel sounds like a better expert, when it comes to combustion. but it doesn't really mean both of them are scientists, so they can invent anything, and they both of them are sufficiently versed in what combustion is or not. But going by their areas, their spheres of research, it seems the other expert definitely is a more suited expert. So I'm judging both of them now. So in this declaration, we see that Dr. Midas reviewed the 170 patent and even point out that there is possibly no combustion involved based on the conclusions of the examiner. So that is pointed out on page 8. So this is page 8 here, and this is where it is saying that it says here on December 4th 2019, the examiner, that is the examiner examining the 170 patent, issued a notice of allowance and a notice of allowability. In the notice of allowability, the examiner described that he had reviewed 5 other patents and patent publications, but disregarded them because those electronic cigarettes are intended to mimic the experience of smoking a combustible cigarette without the actual combustion of tobacco. Therefore, the prior art does not teach or suggest an electronic cigarette having a heating element initiating a combustion. Okay, notice of allowability at 2. Okay, so this is what I think they are trying to allege, that actually too, that the 170 patent, the 170 patent belongs to Hcmc, was actually granted with the knowledge that it actually doesn't combust. I mean, I could be totally wrong with what I'm saying here, but this is what I'm making out of it. Okay, so in this declaration as well, he continued to reassert that the IQOS does not combust even with the presence of carbon monoxide and nitrogen oxide gases. You can see here below. You can see that's the declaration. Okay, so this is where it now continued with the IQOS. Yes, the IQOS system was specifically designed and engineered to heat but not ignite or burn tobacco material. So the point of this whole, our conclusion here is that what is clearly clear is that Philip Morris is still holding on to the fact that Hcmc lost that complaint. The complaint, of course, we know is the first one filed last year. It lost it, and it lost it on the grounds that the FDA's conclusion was that the IQOS does not combust. So it also, the other point is that it is trying to assert that Hcmc cannot invalidate the authenticity of that declaration of the FDA. So, and also points out that Hcmc is relying on that. So if it can't invalidate what it is relying on, that's what it's trying to assert. So at the same time as well, it is also fending off any accusations that the IQOS does combust. At the same time, also trying to trying to assert that the 170 patent, which belongs to Hcmc, does not actually combust on its own. You see that? So it is complicating a lot of things here, complicating the issue, and then at the same time as well, we can clearly see that what is here now, what is in all of these things, is that, especially on the side of Philip Morris, we can see that we know that very well. When you take your product for testing, you do everything in your power to make sure that product passes the tests. But when that product comes out in the real world, it may not pass that test. So what Philip Morris is trying to do is that they are not trying to give any credence to any other tests you are going to do anywhere. As far as the FDA has done that test, it is final, complete, true, And it is, well, yes, it's, well, we have seen that it has been, that has been the case. The case was thrown out because that evidence from from the FDA was there. So maybe it could still be what we are still going to fall back on. Okay, so that's what is strictly relying on. So I've digressed a bit now. What is certain is that yes, you pass the test, but the real world it may not be the case. So it is probably what HCMC is trying to point out, that the product passed the test with the FDA, but indeed what is sold to the public does not meet that, does not pass that test. It has failed the test. So as such, it has infringed on its patent. So that's what we're facing here now. So I'm not an expert, I'm not a legal expert, but I'm just trying my best to explain to review some of these things. So obviously Jossum Sauce would have done a better job, I believe. So you go ahead and find out his video and see what he has to say there. We're going to also see that as well. Okay, so this is the much we can do on, we can review as regards this case, and we'll try our best to also come back and add more flesh to this review. So thank you very much for watching this video.